Dear students, today we will discuss one of the very complicated issue of India's constitutional evolution, and that is the evolution of the constitutional structure and the administrative pattern of presently the National Capital Territory. There are number of cases, constitutional amendments, the technical provisions that a student who may be new to the constitutional history may find understanding things in a perspective challenging. So, let us begin the story. And why am I talking about this story? Because everyone is talking about. And since when? I believe that since beginning, but most recent cause is the passing of the bill which has resulted into giving the control over services to the union government with respect to NCT. It will take hours and hours to discuss the things at length. So, my idea is to give you a perspective so that you can relate different developments and understand that if NCT is seen as a case study in a constitutional evolution of India, then what are the issues that emerge in this case study? So now let us start with understanding this particular issue. The issue is that in recent years, especially since, if I talk about from 2015 onwards, so what does this 2015 denotes? This 2015 denotes that in Delhi there is a AAP government, and at union level there is government of NDA or BJP. So, why in the constitutional history, why I am mentioning the two political parties? Because you have to understand that constitutions do not operate in vacuum, and in any representative democracy, a very important role or the elements of democracy are the political parties. So, without understanding the dynamics of political party, it will be difficult to make sense of the entire development. So, this thing gives you what idea? This thing should give you an idea that Delhi is one place where the double engine sarkar does not exist. So, does it make a difference on the functioning of the administrative mechanisms if it is about the constitutional matters? So, I say yes, definitely, because political parties, they form the essential basis of the dynamics in any democratic country. Now, another thing that whenever you talk about this debate, often we hear the status of Delhi. There has been demands for Delhi to be upgraded as a full-fledged state, as well as there is a conflicting opinion in judiciary. There is a conflicting opinion among the intellectuals about the status of Delhi. What is Delhi? What is the status of Delhi? Where does Delhi fit in our democratic framework, in our constitutional order? To understand this, it is essential also to look into one more aspect, and that is what is the basic structure Indian political system is organized, how our state structure is organized. And you all are aware that India's state structure works on two fundamental principles called as the federal principle and the parliamentary principle. So, without taking some amount of theory into consideration, understanding these complicated issues become nothing more a set of facts, but theory helps in putting the things in perspective. Now, why I have chosen to first talk about federalism and also to talk about parliamentary system or parliamentary access, because our administrative system is based on the federal system. Now, what is a federal system and why federal system? Federal system, says the expert on constitutional issues, Dicey, is where units desire unity without desiring the uniformity. It means that inherent in the idea of federalism is the idea of diversity, regionalism, and how to handle it. Now, we have to understand one theoretical anomaly in the Indian Constitution is that we have adopted the parliamentary form of government. How does that matter? Because ideally speaking, if you have a federal form of government, then you should have a presidential form of government. Now, why? Because the presidential form of government is based on personality, whereas the parliamentary system is based on party politics. And whenever we talk about party politics, comes the distortion in the ideal functioning of federalism, and the issues like double engine or any other discourse or narrative figures into discussion. So basically, our federal system, center and state relations, even Sarkaria Commission and other commissions have time and again told that the center and state, there is no center and state relations in India, it is party to party relations. If same party is at the center and at the state, for which the new buzzword is double engine Sarkar, then what we see, our federal system operates in the cooperative mode. But when the two parties are different, then our federal system gets transformed to from competitive to bargaining federalism. So what do we do see as far as the governance issues in Delhi is concerned. It is working more like a bargaining type of a federalism rather than the cooperative mode. And that is why in 2018, in LG versus or in NCT versus LG case, Supreme Court in 2018 case had to talk about the importance of federalism, and Supreme Court has directed that both the governments, the union government and AAP, it should follow the principle of collaborative federalism. You have to understand that India has avoided any tight mold of federalism, and our model is very much contextual model, whether we talk about our federalism or we talk about our secularism. So the collaborative model is the key for the harmonious functioning of the institution, which expect center and state not to go against each other and compete, but to cooperate in the best interest and to achieve the constitutional goal of human dignity and unity and integrity. The moment we forget the principles, obviously the practice becomes troublesome, quarrelsome and difficult. Okay. Now, in 2018 case, a very important principle was also given, and that is called as the federal balance. So what does this federal balance show? It shows that though India is a cooperative federalism, which for all political practical purposes means a system where center is strong. But federal balance means our constitution has established a very unique federal balance where it has been held that center should remain important, but there has to be an equilibrium and states should not lose significance. I hope this principles of jurisprudence will give some food of thought for you to understand. Now, to understand this issue, we also need to understand India's federalism, which is asymmetrical, means which give a scope for the differential arrangement with different territorial units. Okay, so it's not necessary that all states have to be treated at par. Even if I talk about Article 2 of Indian Constitution, it says that whenever union will establish any state or admit a state, Parliament, it is up to the Parliament to determine the terms and conditions it thinks fit for the purpose. So, we have to be well aware of the fundamental principles to understand the conflict, contestation, and as well as to critically analyze what went wrong where, as well as to have a vision towards how to set the things in order. So now let us start with the story of the legal troubles and the political battles of Delhi. As you know that Delhi got its name from the king Dhilu, and from where this Delhi term has come. And Delhi emerges on the political scene with significance, and we start talking and reading about Delhi primarily when the Chauhans started ruling the Delhi, the Parmars and the Chauhan. You must be knowing about Prithviraj Chauhan. After that, it became a cultural capital of Delhi Sultanate. At the time of Shah Jahan, Delhi reached to the zenith of its glory, and towards the downfall of the Mughal rule, Delhi became the protectorate of Marathas, and then in Anglo-Maratha war, British brought Delhi under their control, and finally in 1911 they shifted the capital from Calcutta to Delhi with the prime reason that there was a rising tide of nationalism in Calcutta. Situations were becoming worse because of the Swadeshi movement or 1909 Act from the perspective of the British administration. So, what has been the status of Delhi at the beginning or at the time of independence? So, Delhi was a chief commissioner's province. So, when you talk about chief commissioner, obviously it means that Delhi was ruled by chief commissioner and had direct access to governor general. And then at the time of Constituent Assembly, Pattabhai Sitaramaiah committee was set up to ponder over the type of governance system Delhi should be having, and realizing this particular fact that Delhi also forms the national capital and belongs to entire India and not just the people of Delhi, Pattabhi Sitaramaiah committee acknowledged that Delhi cannot be given full statehood, but they certainly favored that people of Delhi should not be deprived from the democratic and representative government. Though during that time, Pandit Nehru and Ambedkar, they did not favor the formula, and as such what we see is Delhi continued to remain a chief commissioner province, but at the same time experiment with parliamentary democracy also started. And even at the time of Pandit Nehru, when Pandit Nehru was prime minister, Govind Vallabh Pant was home minister, that time also Delhi's position was unworkable and Delhi's chief minister had to resign. And later on it was realized that because of the overlapping jurisdiction, it will not be possible for or it is not a good idea to have the parallel set of governments, and this has resulted into change in its constitutional status. And we see that in State Reorganization Commission, on the basis of its recommendation, Delhi became the union territory. So, what is Delhi? Delhi is primarily a union territory. It is still a union territory. If we look at Article 239, if we look at the first schedule, where does Delhi fits in? Delhi fits in the union territory, means Delhi is a territory which is under the union's control. Now, on the basis of State Reorganization Commission's recommendation of 1956, Delhi became union territory, and for its administrative purpose, centralization has happened abolition of legislative assembly has also happened, and finally for giving people some sort of accessibility to the governance, New Delhi or accessibility, municipal, metropolitan Delhi Municipal Corporation Act came into existence in 1956, which was also in the news in recent time. But this also failed to satisfy an aspiration, and as a result, the Delhi Administration Act was passed in 1966, which has established a metropolitan council with the elected and the nominated member, some semblance of the council of minister, but the fundamental problem remained in the metropolitan council is it was just a recommendatory body. So if I talk about the present constitutional arrangement, I can say that we are back to the arrangement which Delhi had in 1966, where a legislative assembly was there, but its powers were only recommendatory, as well as a council of minister was also there, but which is directly and very distinctively subordinate to the LG, who is a administrator. Now, as you know that the domestic politics, the Jan Sangh, they raised this issue that Delhi should be made the state, and Congress government, fearing that it may lose the ground, in 1987 they established the Bal Krishna Committee, which has recommended that Delhi should be given the constitutional status, and consequently in 1991 69th Amendment Act was passed, and maybe whenever we read the constitutional provisions related to Delhi, we often ignore that only 69th Amendment is not important. Even 70th Amendment Act is also important, which was added in 1992, which gives a very important provision, that is the power of parliament with respect to the legislative assembly, and it is mentioned that despite legislative assembly, parliament will continue to have power to make laws on the subjects of state list and concurrent list. Means despite legislative assembly has been created, it does not mean that parliament has lost its power. Now you are well aware that 69th Amendment Act make it mandatory to constitute a legislative assembly. It provides for the council of minister. It tells that legislative assembly of Delhi can make laws on different subjects of state list and concurrent list other than police, public order and the land, and certain laws related or offense related to certain laws which are also mentioned. It means the act envisages a huge scope for the governance or self-governance in Delhi. Now, besides this, you should also know that the detailed administration of Delhi is governed by Government of National Capital Territory of Delhi 1992, and determining the mode of the relationship between LG and Council of Minister is certain rules of transaction, which were formed first in 1993, and then it was also revised in 2015 and all. This provided the prima facie thing. Now, the recent trouble started when AAP government came to power in Delhi and BJP at the center. And as you know that AAP has emerged out of India Against Corruption movement. So when they come to power, they started taking the steps. For example, setting up the committees for invigilating certain corruption related charges, establishing anti-corruption bureau, and thus in the entire constitutional cases emerges that who ultimately has power over the services, the appointment, the transfer and other disciplinary matter. And this thing has resulted into the cases after cases. So which cases to watch, which events to watch? So basically you have to keep watch that once AAP government started putting up started setting up the commissions of inquiry and other things, then the first important case is 2016 case, where Delhi High Court has made it clear that Delhi is union territory and in Delhi the real power lies with the lieutenant governor. Now this has resulted into bringing the services under the lieutenant governor, and the root of this is in 2015 when Home Ministry has issued certain guidelines with respect to bureaucracy. Now AAP government had challenged this decision, and then came very important decision, that is 2018 decision, which is a landmark decision where Supreme Court has highlighted how should we be interpreting the provisions related to Delhi. They said that we should look towards not just the letter and the spirit of the constitution. It talked about principles like constitutional morality, collaborative federalism, federal balance, collective responsibility and other principles. A must watch, must read judgment for anybody who wants to understand certain very important guiding principles of Indian political system. So now 2018 judgment has reversed the judgment of Delhi High Court, and it has shifted the balance of power in favor of the elected government, treating collective responsibility as the sacrosanct, and held that LG is more like a constitutional head, though it held that the Council of Ministers should also act with responsibility, considering the special status of Delhi as a union territory and the national security and other related issues. So two things: it instructed LG not to apply the provisions of 69th Amendment Act in a mechanical manner. Which provision are we talking about? So basically the act says that in case of the differences between the LG and Council of Ministers, LG can refer the matter to President for resolution, and if matter is of urgent nature, then LG can resolve the matter on its own. So what does Supreme Court said in this case? Supreme Court said that LG has a discretionary power, but it should not be applied in a mechanical manner. LG can refer any matter to the President in case they differ from Council of Ministers, but it does not mean that LG has to refer each and every matter. You cannot create a situation of deadlock. At the same time, judiciary has also taken a balanced perspective. Judiciary held that undoubtedly Council of Ministers has power. There is a parliamentary form of government, but at the same time, Council of Ministers' duty is to keep LG informed over the administrative affairs. Now, this created a confusion where AAP government interpreted as if the entire power balance or the balance of power has shifted in their favor. So, AAP government started the practice of first taking the decision and then informing LG later. So, this was the ground on which Union thought that it will bring an amendment. Now, what was AAP's concern? Because AAP knew that if they will first refer the matter and LG will say no, so things will not start. So, they wanted to take the benefit of the doubt and they wanted to play safe, or they wanted to defend themselves by bringing the law first and informing the LG later. But obviously, the partisan interest collide and business as usual by AAP could not have been accepted with the India's party, which is now riding, or you can say which is just become the second dominant party in the country. So from then onwards, what we see that Union government, though by bringing every amendment, talks about that it is trying to align the administration with Supreme Court directives, with the constitutional vision, but somehow what we see that gradually the powers of the Delhi government have been consistently reduced and reduced to the extent it will be very safe to say that we have reached from where we started, means the type of arrangement that was there under 1966 ex Delhi Administration Act, where a metropolitan council was existing, but it was just having a power of recommendations. So, three important acts are important now, and that is in 2021 Union government has amended the GNCTD Act, and by which Union government has clearly stated that Delhi government means LG, and every legislative proposal or executive proposal has to be first passed or routed through LG, and then only a law can make, means given the distinct supremacy to LG over the legislative matters. Besides this, we have also seen attempt by the union to bring change in the municipal system, and more or less it projects that the idea is integration of municipalities and to give a better municipal services, but union government's law on municipalities integration is not just about integration, it also takes away lot of powers of the Delhi government over municipalities in terms of constituencies, in terms of the functions, and revives the institution of mayor, which is coming in power at par with the council of minister. And as you know that Delhi is notorious for multiplicity of the administrative institutions involved in a particular task. It is said that even if you have to just get one street light done, you may have to reach or knock the doors of more than 17 departments. People have to move from pillar to post, and still there is no accountability. Who will ultimately be the one with whom people should hold accountable? Are the elected one accountable, or should we hold the, and how are we going to hold the appointed bureaucracy accountable, and where to go for education? Should we go to the municipality or should we go to Delhi government. So lot of confusion. And now very important issue from where the confusion started was with respect to the administration, with respect to the issues related to the civil servants, Group A officials, DANIC officials. And in this context, though in 2018, judiciary has clearly shifted the balance of power towards the Council of Ministers, but as far as on the appointment issue, who will have the power, they have given a split verdict. One judge said LG has a power, other judge said the Council of Ministers has the power, and as a result, a confusion has been created. And again, in considering the leanings of the Supreme Court towards the principles of federalization and parliamentary democracy, the government thought that because this 2021 amendment had been challenged and judiciary had also held that this amendment, the way it changes the position of LG and Council of Ministers, is not acceptable. It goes against the idea of constitutionalism and federalism. I think on 9th of May around the decision came, and on around 11th or some May, Union government has brought an ordinances on the services, which is now become an act, and by this ordinance the issue is resolved, and it is now very much clear that the civil servants are under the authority of LG, and the elected government does not have much say. And according to the union government, they are creating an authority for the appointment of the civil services, civil servants and their civil services board, and this is for the appointment, this is also for the transfer and other things, other disciplinary matters. But the interesting thing is this civil services board or authority will be headed by the chief minister, and it will have the principal secretary and the cabinet secretary. Though chief minister is a chairperson, yet the quorum is 2. It means if chief minister is absent, still this institution can take the decision. So bringing the position of chief minister at par with that of the officials. Now the crux of the problem is, in case of Delhi, the chief minister is competing whether who is more powerful, the chief minister or mayor, or chief minister or the principal and the cabinet secretaries. So the time has come. Once we were talking about who is more powerful, LG or chief minister, but now it's a time to talk who is more powerful, the secretaries or the mayor and chief minister. So this is how things have you can say metamorphosed in something very different, in a something very different perhaps from the intention when 69th Amendment Act has been passed, and now everybody is talking about the new bill and how it will impact. So what are the questions we need to ponder on? We need to ponder on, after all, what is the status of union territory? What is the status of Delhi? So this shows that Delhi is a UT, but it is not like any other UT, not even like Pondicherry, because it is the only UT where legislative assembly's status is constitutionally guaranteed. In case of Pondicherry, legislative assembly will be there or not, depends upon parliament. Fine. Now Delhi is UT, and in the cases you will find it is said it is a case sui generis, it's a unique case. But you have to understand that when Chief Minister says it is unique, means it is more powerful than other UT in terms of legislative assembly's power. Similarly, Supreme Court also believes that it is almost different, but it is more closer towards something, a state, a intermediate formula where idea is to make it a state, but we have to be satisfied with something shorter, less than the state, whereas the union government interpret it as if Delhi's status is sui generis in the sense that it is weaker than other union territories. So, lot of constitutional issues to discuss: parliamentary form of government, representative democracy, constitutional morality, the judicial activism, separation of powers, judiciary versus legislature, UT, asymmetrical federalism, Council of Minister versus LG, Council of Minister versus Mayor, Council of Minister versus bureaucracy, the issue of committed bureaucracy, the issue of federal politics, party politics, and lots. I hope this discussion has given you some perspective to understand the constitutional battles, the legal battles, and the political battles surrounding our Delhi. Thank you.